Either way, you're not leaving the courtroom today. Either way, you're not leaving the Bexar County Jail today.
Thanks.
So what do you want?
When I got out, I did really, really well. Last October, and I had broke my foot. And in the hospital, they gave me.
I was an attorney in felony drug court, and I know people who are serious about their sobriety, whenever they have injuries or they're going to the hospital, those questions are always asked. And if you tell them, I'm in a drug program, they'll try to find you something that's not an opioid to give you. I give you 277 days, whether I give you a year. So this is my question for you. What do you think you deserve?
You are watching the Justice Chamber. Like it, subscribe it, and share.
2018 CR 3998, State of Texas versus Kimberly Michelle Marsh. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Alice Palmerchild.
And good seeing you. All right, Ms. Marsh, I'm showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it? Are you the same Kimberly Michelle Marsh who was placed on deferred adjudication in 2018 CR 3998 for the offense of possession of a controlled substance, penalty group 1 less than 1 gram, on November 15, 2018 for a period of 2 years and extended for a total of 3 years? Is that you? State?
Violated condition number 41 on or about the 25th day of October 2022 in Bexar County, Texas. The defendant, Kimberly Michelle Marsh, then and there failed to comply with the rules and regulations of the Felony Drug Court program with continued use of controlled substances, namely cocaine and methamphetamine, in violation of condition number 41.
How do you plead to that? True or not true?
State waives all the violations.
Any objections to the state's waivers?
No objections to the waivers.
All right. Did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility, and up to a $10,000 fine? Did you understand?
Yes, sir.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition 41 true. Is there an agreement?
No, Your Honor. The agreement is for revocation, but there's no agreement as to.
All right, state, what are you requesting?
State's requesting 1 year in the state jail facility.
Defense, what are you requesting?
Your Honor, we are asking for you to consider the 277 days that she's already served her time, state time served. And lessen the sentence for her.
All right, Ms. Marsh, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. So why did you not do well in felony drug court?
Well, in the beginning, I didn't do well, and I went to PDRF. They discharged me with the alcohol, and I got out. And I did really, really well. I had a relapse in May, and then I thought I had done really, really well up until this past October, and I had broke my foot. And in the hospital, they gave me pain medicine, and it kind of sent me down the wrong path.
See, here's the thing, though. I was an attorney in felony drug court, and I know people who are serious about their sobriety, whenever they have injuries or they're going to the hospital, those questions are always asked. And if you tell them, I'm in a drug program, they'll try to find you something that's not an opioid to give you. So did you not tell them?
No. And I should have. I have been going to my meetings. I have been going to meetings every night. It's just, I failed there.
Mm-hmm. And here's the thing, the court knows the felony drug court program, and I know they don't kick people out because you use, right? They want you to stop using. They want you to maintain your sobriety. Now, what this sounds like to me is there was continued use and no real effort, because if there were real effort, felony drug court would still have you and they would still be working with you. So the state is asking for 1 year. Your attorneys are asking for you to have 277 days. Either way, because this is a state jail felony, they will probably take you to the state jail facility to be processed, whether I give you 277 days, whether I give you a year. So this is my question for you. What do you think you deserve?
I'd like that sentence, and I'd still like to continue with outpatient AA and A meetings. I still would like to continue that. I'd still like.
I mean, no, here's the thing. Let me just tell you, if I were to continue you, you're going to somebody's inpatient treatment. It's not going to be on outpatient.
I would like to go to alcohol.
Mhm. Have you all discussed her trying treatment again or no?
Your Honor, we did discuss that. The state recommended safe.
So it's not going to be Alpha Home for you. That hasn't worked. So it's either going to be SafeP or maybe SATA or maybe ISF. But either way, you're not leaving the courtroom today. Either way, you're not leaving the Bexar County Jail today. So what do you want?
Jail.
All right. And how much time do you think you deserve? This is not what you want. It's like based upon what you've done.
Year later.
Okay. All right. The court will grant the motion and you don't want treatment, correct? All right. When you are released from custody, everything that made you use before is still going to be in the world. And what I can tell you is people who are selling drugs, it's not FDA approved. You may end up with some bad drugs. You may end up ODing, or you may end up getting caught before you use, in which case you're going to have another case.
I plan on continuing outpatient, well, AA and NA when I get out as well. I belong to the lifeguard NA meeting over there on Woodhouse.
Okay. Well, if you want, I can recommend the therapeutic community for you. It doesn't extend the length of time that you're in custody, but I can't force them to accept you. You'll have to ask for it. So would you like that?
What is that?
It's to help you with your drug issues.
Yes.
Okay. All right. The court will grant the motion, find you guilty, sentence you to 1 year in the state jail facility, give you credit for any time served. And the court will request that you be placed in the therapeutic community. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorneys? Did you understand it? And did you sign it?
Yes.
All right. This is not a plea bargain agreement. You do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand?
I think so. I have one.
Yes.
On the therapeutic community, does that mean I can't go home?
No. What that means is for the remaining of your time, if they accept you in the program, you will be there.
Oh, okay. Yes, ma'am. Absolutely.
No, this is for you. Yes. One for you and one for your client. All right. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right. Good luck to you, Ms. Marsh. You can either do that. If you don't want to do it, you don't have to do it. I can send you to prison.
No, I'd rather not go to prison, ma'am, because I feel that I don't belong there.
All right. Well, you belong at DDR. I understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine. Do you wish to plead true to violation of condition number 2?
Yes, ma'am.
2019 CR 11429W, State of Texas versus Jacqueline Kate Wood. Could I have parties announced for the record for the state?
Catherine Pollard.
Defense.
Michael White for defense.
And are you Ms. Wood?
Yes, ma'am.
Showing you what's entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Jacqueline Kate Wood who was placed on deferred adjudication in 2019 CR 11429W for the offense of aggravated assault with a deadly weapon on October 16, 2019 for a period of 4 years? Is that you?
Yes, ma'am, it is.
State?
Judge, it's a violation of condition number 2 on or about the 6th day of December 2021 in Bexar County, Texas. The defendant, Jacqueline K. Wood, did then and there illegally use a controlled substance, namely methamphetamine, in violation of condition number 2.
How do you plead to that? True or not true?
True, ma'am.
The judge will waive the other alleged violations.
Any objections to the state's waivers?
No, yeah.
All right, Ms. Wood, did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do understand.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, ma'am.
Court will find violation of condition number 2 true. Is there an agreement?
Yes, Judge. We're asking for amend for DDRF and then the MIC caseload upon release.
All right. My understanding, DDRF, that's 32 weeks, so that's not going to happen. So, yes. 48 weeks. All right. So anything that's above 20 weeks, DDRF is out because I can't have someone sitting over at the jail waiting for transfer that long. Talk to your legislatures about that and about funding. I can't do anything about that. So, yes.
4 to 8.
Oh,
Sorry.
somebody has talked to the legislature. Wow, it's only 4 to 8 weeks. So, do you want me to follow that agreement?
Actually, ma'am, I don't feel that DDR would be a fix for me, because my mental frame of mind now is way different than what it was when that TAPI valve was done earlier in the year.
Are you on medications?
I've been trying to get on my medication since I've been here in jail, and I've been trying to get in with the Center for Healthcare Services to get put back on my medication.
All right, so here's the thing, Ms. Wood. You're on deferred adjudication for an offense that could result in you going to prison for 20 years. Everybody has an idea of what their program should be. Everybody wants to write their own program. I appreciate that. I internalize what you're saying to me. But here's the thing. If we could all write our own programs and we were doing great at it, we wouldn't be here. Like you wouldn't have been using because you would be on your program, your own program, and you would be doing just fine on it. So obviously that's not working. So I'm going to deny the motion. Alter the main conditions to include the MIC evaluation, DDRF, because I see here, I've tried intensive outpatient treatment with you. Usually what I start everyone on is intensive outpatient treatment, and you have been unsuccessful on that. So obviously this third party needs to write your plan. So that's what we're going to do. And you have children and you need to start thinking about your children.
May I say something, Your Honor?
Sure, you can, but it's not going to change the fact that you're going to DDRF.
Well, I understand that, Your Honor, but since I've been incarcerated, I've participated in AA meetings, and I've also been acting as trustee within my pod and doing good and positive things. I've also, through CPS, completed outpatient drug counseling back in 2020 with a Dr. Castillo.
All right, but that outpatient treatment didn't work. So you're doing DDRF. You can either do that. If you don't want to do it, you don't have to do it. I can send you to prison.
No, I'd rather not go to prison, ma'am, because I feel that I don't belong there.
All right. Well, you belong at DDRF. Thank you.
Please share your thoughts in the comments and subscribe for more compelling cases. Thanks for watching. The Justice Chamber. In 2018, Kimberly Michelle Marsh was placed on deferred adjudication in Behar County, Texas, for possession of a controlled substance, specifically less than 1 gram of a penalty group 1 drug. She was sentenced to 2 years of felony drug court supervision, which was later extended to 3 years. The program was intended to support her recovery while helping her avoid incarceration, but that path took a serious turn. On October 25, 2022, Marsh violated the conditions of her supervision by continuing to use cocaine and methamphetamine. She admitted to struggling with sobriety, explaining that a broken foot and prescribed pain medication contributed to her relapse. However, despite recognizing the risks, she failed to report this setback to court staff, which further complicated her situation. During the hearing, the court emphasized that continued substance use while under supervision carries significant consequences. Marsh's attorneys requested that her previously served 277 days be credited as time served, while the state pushed for a full 1-year sentence in a state jail facility. Ultimately, the court found the violation to be true, revoked her community supervision, and sentenced her to 1 year in state jail, with credit for time already served. The court also recommended placement in a therapeutic community to support her rehabilitation following incarceration. This case highlights the serious consequences of relapse under court supervision, showing how even temporary injuries and prescribed medications can trigger a chain reaction leading to incarceration. It reflects a complex mix of human vulnerability, personal responsibility, and strict legal enforcement,